I was talking with the head of the chambers, and they were sort of saying, well, do you think... We were saying, like, do you need a first? Do you need, like, would you consider people with the 2-1 kind of thing? And he was like, no, like, you pretty much need a first. Like, everybody has a first. And, yeah, like, most people here have been to Oxbridge. They've got a first, so, it's a tough competition. And I think somebody said, like, oh, well, what do you think about a first from St Andrews? And they were kind of like, yeah, that's probably... Jeff, is that okay? Yeah, that's okay. That's okay.
What time graduate?
Me, a first. Well, the chambers are just in different inns, but you're not really attached to the inn necessarily. I have a scholarship from Lincoln, so I have to be a member there.
Okay.
But
scholarship now.
Yeah.
Did you scholarships for non PTC?
Sorry.
Did you scholarships for non PTC?
Yeah, so they do scholarships for any conversion years.
Oh, of course, this will count as conversion year because
yeah,
that's right. Plus Lincoln's has the. Are you in the dining scholarship? Wait, is it down?
Is that Lincoln's? Denning.
Denning, sorry.
Yeah, I'm on the Denning.
Oh, okay. Do you know all about Mitchell? Because I know the Denning Society has sort of little get-togethers.
Really? I haven't been invited to that. Let's see how it is.
Not yet. Or maybe it's...
I haven't actually been to one of their events yet, so I need to schmooze my way through.
Well, it might be a Barclays thing, because my friend is, who was on the Barclays last year was on the Denning Scholarship as well, and apparently they have to get-togethers.
I know they have the sort of Denning dinners. And
that's the one, the Denning dinners.
Yeah.
They love their alliterations.
Very unimaginative, that one.
All the pictures they can now. Where this is deed. Is it? No, yeah. No?
Do you tend to refer directly from the material, or do you just reference it? Do you tend to go through, like, statutes or whatever and find what the reference is, or do you just, like, write it out, find all the references?
She was recording, like, since she came here.
Oh, right, okay. Yeah.
She was recording for 20 minutes there.
Yeah.
I used to write
And the battery.
Yeah, so did I. Yeah. Yeah, I thought about. I just thought. I didn't. Provided you don't get tripped up, I think not finding it's better. But obviously, if you write it, you just got that security.
The thing is, she never really referred.
Did you speak to us about the
You've already thought of it, so yeah.
In the previous 2 rounds, are you happy to do the buttons? And the first one, usually a couple of minutes. One of these usually in the previous, it's only usually about 2 or 3 minutes, and it's usually in it out. To do the rebuttal. And then, obviously, you your respondents, it's rebuttal, yeah. So, they've done it in the last 2 rounds, and it's been quite...
Right. So, you want to stir a rebuttal as well as a rebuttal? Okay, good.
Yeah, so literally,
2 minutes.
Miriam will get up. Right, okay. Do you have the next scenario printed down?
Yeah.
Could you give that to the judge, please? Because for some reason I think I forgot to.
Yeah, don't worry.
I've been manic for me. I've got so many things to organise with the Royal Society this last week, and I'm trying to get them all done because I want to get back into my dissertation. So Miriam will stand up and do 2 or 3 minutes, and then you will stand up and do. Only if there is something to say. Obviously, only if there's something to say.
Yeah, 2 minutes, I think. Yeah.
That's quite enough, right?
Yeah.
Unless I see lots of wrongs.
Yeah.
You can limit hope that 2's enough.
Yeah.
Okay.
Yeah.
Sorry, what was your name again? You're Matthew. Yeah, do you know where it is?
No.
Right, so it's just I'll be just playing my
Oh, thank you.
So we're going to do 2 minutes rebuttal. Miriam, Senior Counsel, and Darren. They've done it the last 2 rounds. Each discretion. because I know it's really good because I don't
As if I knew.
Simon remembered to bring the score sheet. Sorry, I've been a bit disorganised. In my defence, I've been in lecture since 10 a.m. this morning until yes, I know you've been there too. So you can't say on Thursday. So we've got some still water and that's all. Is it, how many minutes is it each girls? 15. We don't normally stop the clock, but if you've interrupted and it's taken a bit longer, we just allow. I've sort of mentioned that it's gone time. Have you given your?
Into cases and statutes, it'll be easier for them. So those are the statutes, the other authorities and cases. Yes, it was at the front.
Thank you.
Give me 2 seconds to read this and then we're ready to go.
If it pleases my lord, my name is Meriam Altaf, and I'm senior counsel for the appellant Anthony. And my learned friend Hamida Husseini is a junior counsel. Across the way is my learned friend Darren Lowe, who will appear as a senior counsel for the respondent Secretary of State for Transport acting through the Driver and Vehicle Licensing Agency, and my learned friend Matthew Kellyris Thomas will represent respondent as a junior counsel. My lord, would you like me to state the facts of the case?
No, I'm familiar with them. Thank you very much.
I'm a pleasure. My lord, can I proceed with the submissions?
Yes, please do.
I'm a pleasure. I will be making 2 submissions in furtherance point of this appeal. First submission. According to Section 92.2b of the Road Traffic Act 1988, Anthony's tenure of diabetes isn't likely to be the source of danger to the public. And second submission. Anthony is entitled for the license to drive as the risk of having hypoglycemia without warning is minimal. My lord, can I proceed with the first submission?
Yes, please do.
I'm obliged. According to Section 92.2b of the Road Traffic Act 1988, Anthony's tenure of diabetes doesn't amount to be the source of danger to the public. I would like to refer your lordship to the tab 1. Section 92, subsection 2b of the Road Traffic Act 1988, that states, a person is not fit to drive if the disability is likely to cause the driving of a vehicle by him in pursuance of a license to be a source of danger to the public. I would like to further refer your lordship to the tab 2.
Yes.
Guide for medical professionals to the page 8, where it stated, taxi drivers should meet the same medical standards that Group 2 bus and lorry drivers must meet under the DVLA's requirements. I would like to further refer your lordship to the tab 2A. Appendix D at page 115, that states, hypoglycemia, also known as hypo, is the medical term for the low blood sugar level. If I could also ask my lordship to look at the following paragraph that defines severe hypoglycemia as requirement of another person's assistance. I would like to further refer your lordship to the tab 2B. Page 63, where it stated, impaired awareness of hypoglycemia is an ability to detect the onset of hypoglycemia because of total absence of warning symptoms. And lastly, if I could refer my lord to the tab 3. National Health Service Statement at page 1, paragraph 6, that states, typical signs of hypoattack are feeling hungry, trembling, or shakiness and sweating. It is also possible for hypoattack to occur during the sleep, which can cause excess sweating, disturb sleep, and feeling tired and confused upon waking. At tab 3A, paragraph 7, it is also stated, the immediate treatment for hypoattack for those who aren't insulin dependent is to have some food or drink that contains sugar. My lord, I would like to refer you to the tab 4. The case of Bennington and Peter, 1984, road traffic records. Would you like me to state the facts of this, my lord?
No, I'm familiar with them.
I'm obliged. My lord, I would like to refer you to the tab 4A, page 4, paragraph.
Yes.
Where it stated, medical experts over the past decade have formed the opinion that diabetics requiring treatment by means of injections of insulin shouldn't be permitted to hold a heavy goods vehicle licensing. I would like to further refer your lordship to the tab 4B, paragraph H, where it is stated. The medical advisors to the licensing authority, who also advised the Secretary of State for Transport in relation to driver licensing, had obtained the driver's medical records from his general practitioner, which made it apparent that the driver's diabetes could only be treated by injections of the insulin. With regards to our case, my lord, respondents may argue that Anthony is a danger to the public as he experienced in the past occasional hypo attacks. However, my lord, there are no medical records that show the severity of the appellant's disease. In the case of Bennington and Peter, there were all evidence and medical records that show that appellant's disease is at fourth stage, and therefore it was danger to the public. The driver had more severe form of diabetes, meaning he couldn't survive without any injections of the insulin. With regards to our case, my lord, we cannot assume or predict the health position of the appellant. We have to strictly rely on the facts of the case. The heart of this case is the severity of the disease and to what extent appellant is aware of it. For the history of the appellant's career in driving, for 30 years, he doesn't have a single medical record of having an attack while performing his job. As we stated earlier, hypo attacks aren't treated, they turn into severe hypo attack, and then requirement of hospitalization is needed. As in our case, we do not have such records, thus means he always managed his health conditions appropriately. We have medical records about his condition during his private hours, when he is not working, during the night, that states that he had occasions of experiencing hypo attacks and as facts suggest treated it immediately without the requirement of an assistance. Thus means he is aware of his body and steps that he has to take in order to prevent the attack. My lord, it is clear that Anthony's diabetic condition isn't a source of danger to the public, as it is clearly expressed that he is aware of the symptoms. There are no evidence to suggest that he has experienced any complications in his disease, incidents, or hypo attacks while working. My lord, can I proceed with the second submission?
Yes, please.
I'm obliged. Anthony is entitled for the license to drive as the risk of having hypoglycemia without warning is minimal. I would like to refer my lord to the top 5. Local diabetes community reference to paragraph 1, which states, hypo-unawareness is a situation where people with diabetes, usually type 1 diabetes, are frequently unable to notice when they have low blood sugar. I would like to further refer my lordship to the tab 5a. Which states, having a period of frequent hypoglycemia and hypo-unawareness can be caused by a recent hypo in the last day or two. Hypos can also be harder to spot when they follow a rapid drop in blood sugar levels. Some medications, including beta blockers, can also lead to hypo-unawareness. Other factors that can contribute to reduced hypo-awareness are stress, depression, or consuming alcohol. If I could now please refer my lordship to the tab 6. Case of Regina and Nigel Whitby, 2013, Court of Appeal, Criminal Division, at page 34. Would you like me to state the facts of the case?
No, thank you.
I'm obliged. If I could please refer my lord to the tab 6a, page 4, paragraph 8, where it stated, hypoglycemia wasn't a problem. He may have had an episode once a week or fortnight, but he had always recognized the warning symptoms. Professor Bogdansky found that the applicant was unaware of the steps recommended by the DVLA, which he should take for safe driving for someone with insulin. With regards to our case, my lord, hypoglycemia is not a problem. Appellant occasionally experienced hypoattacks at night. However, he always recognizes the warning symptoms and consequently avoids any kind of complications. What is important in this case is the knowledge and understanding of the DVLA requirements. If I could refer my lordship to the tab 7, page 63 of the Guide of Medical Professionals. As you can see, insulin-dependent drivers are allowed to drive if they are compliant with the set criteria of the full awareness of hypoattack, no episode of severe hypoattack, and understanding of the risk of hypoattack. My lord, if I could refer you now to the sub 7. Again, as you can notice, drivers who treat diabetes by medication other than insulin are allowed to drive if they have no episode of severe hypoattack in the last 12 months, full awareness of hypoattack, and self-monitoring and understanding of the risk. My lord, Respondents may argue that there is no evidence that the appellant doesn't have an impaired awareness of hypoattack. However, it is the matter of fact that he would not be able to drive without understanding of the steps that he has to take. The heart of this case is an awareness of the steps that have to be taken that are established by the DVLA, as they institute particular criteria and compliance measures for all types of diabetes. DVLA guidelines exist for protection of drivers with certain health conditions. The DVLA doesn't state that people with hypoattack shouldn't drive at night. All what they say that it should be treated accordingly. However, our client took all precautions to avoid even a slight risk of having the hypoattack. That is why he has never driven and never will drive during the nighttime. As facts state, appellant has never had a severe hypoattack, which means he took all precautions at the initial stage of hypoattack to avoid severe hypoattack. This means he is aware of his condition and DVLA guidelines. Therefore, the driver is safe on the road, doesn't pose any danger to the public, and is not likely to cause any harm to anyone. If I could please refer my lordship to the tab 6b.
Yes.
Page 6, paragraph 16, where it is stated. The applicant's wife had been in hospital. That led to the stress levels which on the medical evidence could have led to the applicant's hypo episode, an episode which came on without warning. The single error in the applicant's case was the failure to check before he left the hospital. With regards to our case, my lord, respondents may argue that driving in London and having another psychiatric condition increases his chances to be stressed, and consequently increases chances of having an unaware hypoattack. However, we do not have any evidence and medical records that show that appellant had experienced any unaware attacks in the past or any unmanaged attacks while he is on the road and during his off-work time. Moreover, there are no medical records to show that there is a correlation between the two diseases. Therefore, they should be treated as separate symptoms which are as recognized by the medical professionals and the DVLA perfectly treated by the appellant. My lord, 30 years of driving without a single incident makes appellant an expert, a responsible expert that owes duty of care to the passengers, pedestrians, and other motor vehicles in the road. This job is appellant's livelihood. The fact that he managed to be driver in the city of London without any incidents is not luck, but responsibility of knowing the law, managing your condition as the law requires, and incredible awareness of owing the duty of care to those who are around you. I would like to further refer my lord to the tab 8. Safe, secure, sustainable demonstration services agencies guide, at paragraph 229, which states.
Yes.
It is important that the DVLA is called on to make a decision on an individual's fitness to drive. It should have complete and accurate information. However, there is a balance to be struck between making the decisions as quickly as possible and ensuring they are based upon the appropriate information. My lord, with regards to our case, it is important to understand that appellant has an awareness and compliance of the diabetes condition that he possesses. Therefore, he is fit to drive. The decision that was made by the DVLA was made without proper analysis of the condition, its treatment, and particularly without the measurement of the risk of posing danger to the public. I would like to further refer your lordship to the tab 9.
Yes.
Memorandum submitted by the British Diabetic Association to the paragraph 11.7, where it is stated. The British Diabetic Association wouldn't support a system which allows individuals who might be a danger on the road to drive our vehicles. However, as Dr. McLeod said in his report, maximizing road safety is in everyone's interest, but cannot be justifiably achieved by restricting the driving privileges of those who have consistently been exonerated from claims that they pose a significantly greater risk than the general driving population. With regards to our case, my lord, it is of course clear that it is in the interest of the DVLA to do all in their best interest to maximize the road safety. Such restrictions cannot be possibly justified if they are achieved by unreasonable limitations of driving privileges. Appellant doesn't have any medical records or evidence of a clinical instability of his condition. Present evidence of the case show that Anthony is fully and positively adapted to his health circumstances. Restricting appellant from the possibility to drive is also a restriction to the right to work and the right of equal treatment without no justifications. Appellant has been cooperating with the DVLA guidelines for decades. This is a clear confirmation of his understanding of the responsibility that lies upon him. My Lord, for the reasons set forth above, I respectfully request the court to allow the appeal. If you have no further questions, my learned junior counsel will now deal with the second ground of appeal.
Before you sit down, Ms. Altaf, just help me with one matter. Section 92 says that any other disability likely to cause the driving of the vehicle by him pursuant to the licence to be a source of danger to the public. What approach should the court take? Is it for the appellant to prove that it is not likely that his driving will be a source of danger to the public, or do you submit that it's for the DVLA to prove that it is?
It is in balance of probabilities, my Lord.
On who, though?
How likely it is to cause danger to the public. On the appellant.
On the appellant, on the balance probabilities, to prove that it's not likely.
Yes.
Thank you very much. Thank you. Yes, Mrs. Sexton.
I'm obliged, my lord. May I proceed, please?
Yes, please.
Thank you. If it pleases your lordship, I'm Hamida Hossaini, and I appear as a junior counsel representing the appellant Anthony. I shall be making one submission in furtherance to point of appeal, that Anthony's psychiatric condition, psychosis, is not deteriorating, and Anthony's condition does not impose risk and danger to the public. My lord, may I proceed with my submission, please?
Yes, please do.
I'm obliged. On the balance of probabilities, my client does not impose a risk to the public safety because, first, both my client and driving vehicle licensing authority DVLA accept that he's safe while his condition is managed, and second, he has lived with and managed his conditions for decades. My learned friend stressed earlier in her first submission that taxi drivers should meet the same requirement as lorry drivers do, my lord. I would like to draw your lordship's attention to tab 10 of the bundle, please.
Yes.
The Road Traffic Act 1988, section 92, subsection 2, which reads as, relevant disability in relation to any other person means A. Any prescribed disability, and B. Any other disability likely to cause the driving of a vehicle by him in pursuance of a license to be a source of danger to the public. Psychosis in this case is classed as a prescribed disability. My lord, can I refer you to tab 10A, please? Disabilities prescribed in Group 2 licenses is known as a severe mental disorder under the rule of Motor Vehicle Driving Licenses Regulation 1999. Regulation 71, subsection 1B as a severe mental disorder. I would like to draw your lordship's attention to tab 11 of the bundle, please. United Kingdom National Health Service, NHS, at page 1 and paragraph 1. Psychosis is defined as a mental health problem that causes people to perceive or interpret things differently from those around them. My lord, at the same page, paragraph 2 shows different types of psychosis. They are schizophrenia, bipolar, psychotic depression, and drug-induced psychosis. My lord, the symptoms and length of the illness from person to person and the facts are silent on type of the symptoms and length of illness vary from person to person, and the facts of the case are silent on what type of psychosis the appellant is suffering from. It can be any of the above, my lord. I would like to draw your lordship's attention to paragraph 3, where it states that the two main symptoms of psychosis are hallucination and delusion. My lord, can you please turn to page 3, paragraph 15. Common treatments of psychosis can be 1. Antipsychotic medication, which which can help to relieve the symptoms of psychosis. 2. Psychological therapies, one-to-one talking therapy, cognitive behavioral therapy. It can include families and friends, intervention instead of hospital treatments. 3. Social support, such as education, employment, or accommodation. My lord, NHS has confirmed that one possible way of curing psychosis is getting them involved to social support, such as employment. If DVLA revokes his driving license, it will more likely to deteriorate his psychosis condition. I submit that my client's condition would get better by working and socializing. My lord, my client is no risk to threat to the public in any way, as it appears from the facts of the case that he is managing his condition and he is well and stable. My lord, I would like to draw your attention to Chapter 12 of the bundle in Chapter 04, Psychiatric Disorder, Assessing Fitness to Drive, at page 71. One of the categories of psychosis mentioned is severe anxiety or depression. Licensing may be granted after 6 months if 1. The person has been well and stable. 2. Is not taking any medication with side effects. And 3. Licensing will be permitted if symptoms are under control. I would like to refer your lordship to page 722. Another category of psychosis are acute psychiatric disorder or schizophrenia. Licensing may be considered if all of these conditions are met. 1. Remain well and stable for at least 12 months. 2. Adheres to any agreed treatment. 3. Regain insight. 4. From any medication effects that would impair his driving. 5. Subject of a favorable report from specialist. My lord, it appears from the facts of the case that my client sufficiently satisfies all conditions imposed on a person with psychosis, or in another word, mental health problems. There is no evidence for us to suggest that what type of treatment he is receiving. We therefore cannot assume that his medication may or may not affect his driving. He may not even take medication, my lord. He perhaps use psychological therapy. All we know is that he is managing his condition, and he has been doing so in past decades. And it has never changed, my lord. It's important to remember that each and every case and psychosis will be treated differently and affects people in different ways. Just because my client has a particular type of psychosis or treated in different way does not mean that his driving should be taken away from him. This is simply because psychosis, the way it's treated, does not certainly affect everyone in the same way, as stated earlier. Anthony has been able to manage his condition for decades. On the balance of probabilities, my lord, it is more likely that he will do so. My lord, there is no evidence to suggest that his condition is deteriorating. He has learned to live with his condition without experiencing any significant obstacles or difficulties. As far as his psychosis is concerned, he is very capable and takes responsibility for his condition and his health. I would like to draw your lordship's attention to tab 13, case of Carrot and Advocate General, which was reported on the year 2006. Its post-law time at page 33. Would your lordship like me to rehearse the facts of the case?
No, that's fine.
I'm obliged. My lord, it was stated at page 6 and paragraph 6.
Yes.
The DVLA did not act reasonably in taking a decision to revoke the person's license on the basis of opinion expressed by Dr. Locke. And without conducting further inquiries, she felt that Dr. Macaro's evidence was particularly important, in that it had never occurred to her that the person's driving could constitute a danger to the public. On the basis of her physical condition, she invited to hold that the defendant had not made sufficient inquiries, such as would justify a reasonable exercise of discretion to take the decision to revoke and to hold the person's disability. Was not said that her driving was likely to cause a danger to the public. My lord, can I refer you to chapter 15 of the bundle, please, at page 8 and in the middle of paragraph 9. It was noted that I accept that the person had learned to live with her condition. and had taught her driving responsibly. She was able to anticipate when it would be unwise for her to drive, in view of her state of health. She would not drive when she felt unwell. She has been driving for 20 years. There was no evidence that she had ever driven a car in a careless or unsafe manner. My Lord, similarly to our case, my client has an experience of 30 years of driving. There is no evidence to suggest that he has been a source of danger to the public, or it is unsafe for him to drive. The DVLA also accept the fact that Anthony has always managed his condition. As long as he manages his condition, he will not be a danger to the public. My Lord, can you please turn to tab 16 of the bundle? I would like to distinguish the facts of Irene Stewart Mills and Security of the State for Transport 2000, Sheriff Court with the present case. In 1995, the Percival was prescribed antidepressant medication, but Percival did not wish to take it. In 1977, Percival was diagnosed as suffering from a hypomonic illness, and she refused to take medication. In 1988, the Percival had suffered from a psychotic illness. And 1999, the medical evidence showed that she suffered from mental disorder, but all medication and treatment was refused. I would like to refer your Lordship to tab 17 of the bundle, please.
Yes.
The court stated at page 11 and paragraph 3 that if the Percival had come forward with evidence to show that her condition was under control, the situation might be different, but there was no such evidence. It was further stated at the same tab, my Lord, page 15 and paragraph 5. Without medication, which the person was unwilling to take, the chance of an improvement in her condition are greatly reduced. This is thus a real possibility that the condition will deteriorate. To apply the principles into current case, in the present case, there is no evidence of him being a risk to the public. He is a very competent driver and well. His psychosis is very stable and he is fit to drive. My Lord, respondent may try to persuade the court that Anthony is not competent to drive, especially like my learned friend stressed earlier. In a busy place such as London, where a complex problem-solving skill and attention are required to be able to maintain a safe driving. However, my Lord, driving is a complex skill which is learned by practice. My client has driven for 30 years, and there is no evidence whatsoever that he has been a slight risk to the public. My client is perfectly stable to drive when his condition is managed. Also, to be a source of danger to the public, my Lord, it must be more than a bare possibility. My Lord, as a appellant shows a rational degree of judgment when driving, he therefore does not impose a risk to the road users, passengers, or only anyone who's around him, in short, to the public. I would like to refer your Lordship to tab 18, case of Devon County Council and Hawkins, which was reported on the year 1967, Weekly Law Report, Divisional Court at page 285. I would like to distinguish the facts of the case. Would you like me to remind you the facts of the case, my Lord?
No, that's fine, thank you very much.
I'm obliged. My Lord, can you please return tab 19 of the bundle? Lord LG stated at page 5 and in the middle of paragraph 27, in my judgment, that is in general right, the respondent, as it seems to me, was suffering from a condition which no doubt is probably termed as a disease, a condition of epilepsy, whereby he is subject to attacks, and as the facts show, these drugs prevent those attacks. In other words, prevent the disease from manifesting itself. And so long as drugs are necessary to prevent the manifestation of disease, the disease, in my judgment, remains. But, my Lord, it is clear from the facts of the case of Devon that the respondent had suffered from epilepsy and had up to 11 attacks in 5 years' time. The last attack was on 1963, just 4 years before the judgment. The medication was used was just to practically eliminate the chance of another attack from happening. In furtherance of my statement, I would like to draw your Lordship's attention to tab 12 of the bundle, please.
Sorry, tab
20, please.
Yes.
Under the rule of motor vehicle driving license regulation 1999, Regulation 73, subsection 8. An applicant for a Group 2 licensing suffering from epilepsy should satisfy the set criteria for driving license to be considered. It states that the driver must A. During the period of 10 years, immediately preceding the date when the license is B. Granted. 1. He has been freed from epileptic attack. And 2. He has not required any medication to treat epilepsy. And 3. That the driving of a vehicle by him in accordance with the license is not likely to be a source of danger to the public. My Lord, as you can notice, respondent in this case clearly does not satisfy any of the conditions above. Therefore, we cannot generalize all diseases and treatments under the same condition. Appellant is using medication to treat the disease and keep it stable. He satisfies all the conditions and criteria for his driving license to be considered. This means that if disease is treated, it does not go out of control and therefore does not diagnose like an epilepsy. Epilepsy tends to be more serious than psychosis disorder. It is clear that whatever treatment appellant takes, it prevents him from having uncontrolled situations. The only reason is because it's managed. And as far as it will be, there is no danger to the public. My Lord, it's very essential for my client and his health to have his driving license as it is central to his functional autonomy of psychiatric illness. For my client, his driving license means his independence, the ability to care for himself, and the freedom to travel when he wishes. It is his livelihood. Finally, it will be one possible way to prevent him from suffering another psychotic episodes. For the reasons set forth above, I respectfully request to find it on favor of my client, my Lord. And the correct approach in law would be to allow the appeal. If I can be no further assistance, my Lord, that concludes my submission.
There's only one matter I'd like you to help with.
Yes, my Lord.
And in a way, it goes back to the submissions made initially. If you go to tab 5A,
Yes, my Lord.
please. You submitted to me that that there's no correlation between the two conditions of, in fact, I think that was in your submission, between the psychosis
Yes.
and the diabetes. If you look at tab 5A, one of the matters identified there is that somebody suffering from stress or depression, and they're just examples, could contribute to reduced hypo-awareness. Surely, if he were to suffer a psychotic episode, that too would reduce his awareness of the danger of a hypo episode. So there is a correlation in that respect between the two conditions.
Yes, there is a slight correlation. For example, if my client is suffering from diabetic and he is suffering from psychotic, the disease he already have might distress him and make him stress about his diabetic, and it can help him to have psychosis. But it's not certainly the case, my Lord, because each disease and each psychosis will be treated differently. Therefore, I submit that it will not be a correlation between the two diseases, because each disease will have different treatment and different ways to deal with.
Thank you.
Thank you, my Lord.
Yes, Mr. Lord.
I'm obliged, my lord. May it please the court. My name, as has already been indicated by my learned friend, Meriam Altaf, my name is and I appear on behalf of the respondent on the first round of the appeal. Joining me is my learned junior, Mr. Clarice Thomas. If I may beg your lordship's indulgence, I would like to first go through the legal framework surrounding the grant of a driver's license, adding to what my learned friend Ms. Altaf has already gone through. This is crucial, my lord, because we submit that in revoking the appellant's license, the Secretary of State has reached a conclusion that the appellant was a likely source of danger to the public. Now, if the Secretary of State reaches such a conclusion, the Secretary of State has no discretion in the matter, but rather is required by statute to refuse the grant of the license. It's mandatory, it's not discretionary. And this, my lord, is to be determined on the basis of objective medical evidence. Nothing more and nothing less. If I may request your lordship's attention to be turned to the case bundle. Yes, in fact, particularly at tab 2.
Swaffham Justice.
Pardon?
The Swaffham Justice case.
Sorry, the statute bundle. My apologies.
Oh, sorry. What is it? Case.
Yeah, I was intending to go through the legal framework. Sincerest apologies.
Yes.
Yes. This is the Road Traffic Act 1988.
Yes.
And it's stated at Section 92, Subsection 3, that if it appears from the applicant's declaration that the applicant is suffering, are you with me, Mother?
Yes, I am.
Yes. Is suffering from a relevant disability, the Secretary of State must, subject to the following provisions of the section, refuse to grant the license.
Yes.
This is the first submission which we make. The Secretary of State has no discretion if it's satisfied that the applicant suffers from a relevant disability. If your lordship would then look above, it's quite confusingly structured, to section 92.2. Relevant
of an hour, I should say.
yes, indeed.
Yes.
Section 92.2, subsection B, provides the definition of relevant disability. Now, if your lordship may then turn to tab 3. Tab 3 is the motor vehicle regulations, which expounds on the definition of what a prescribed disability is, and if not, what the appellant has to show if it chooses to avail itself of the saving provisions in section 92, subsection 4. Now, with regard to the first ground of the appeal, and particularly with diabetes, your lordship would find relevant paragraphs in section 73 of the motor vehicle regulations. Yes. Now, and in particular, section 73, subsection 6. And this states that diabetes mellitus is a prescribed disease for Group 2 licenses if the appellant has experienced one or more episodes of severe hypoglycemia during the previous 1-year period, or does not have full awareness of hypoglycemia. Now, the respondent submits that whether or not the applicant or the appellant has full awareness of hypoglycemia, or he has suffered a severe episode of hypoglycemia. These are facts which are to be determined by objective medical evidence. Now, if I may remind your lordship that the parties have, in fact, before today, agreed not to submit or to invite this court to make new findings of fact, but rather to apply the uncontested legal principle to the fact that is to be determined at the case beforehand. And that is, what is the significance of the fact that Anthony has suffered from hypoglycemic attacks, but has not suffered it during the day in the past, or rather there's no objective medical evidence. Now in this regard, the respondent humbly submits that the legal test and the key word which we invite your lordship to apply is whether or not simply that the appellant is likely to be a source of danger to the public. That's all your lordship needs to apply today. If your lordship is happy with that submission, I will then move on as to what constitutes the legal definition and following on from that, the legal effect. Unlike my learned friend's reliance on the case of Bennington and Peter, You can refer to that bundle if you do wish to do so. We wish to direct your Lordship's attention to a crucial paragraph in that case, which was in fact given by Mr. Justice Wolf, as he then was. And this can be found, this is the one, this is the West Law. It can be found at page 9 of the Westlaw report. And I see, and we've kindly briefly highlighted the sections. In fact, I would like to, now, Mr. Wolf, Mr. Justice Wolf, as he then was, in this case, expounded on what it means to, what likely means. And in his judgment, likely means, while not probable, could well happen, be more than a bare possibility. Now this, the respondent submits, is the legal principle to be applied in this case. The legal test is not whether or not the applicant doesn't suffer hypoglycemic attacks at night or in the morning. That is not the legal test. The legal test is whether or not he's likely to be a source of danger. And in this regard, the respondent submits that he is likely to be a source of danger. There is more than a bare possibility that he is a danger to this to the public, and the reason being that the objective medical evidence has shown that he is a person who is susceptible to hypoglycemic attacks. Now, it's crucial that the medical evidence and the doctors which have examined the appellant have not reached a conclusion, a medical conclusion, that he will not suffer a hypoglycemic attack in the day. Now, if the doctors have reached such a conclusion, then we accept that then it would be quite arguable that it's likely that he is not a source of danger. However, in the absence of such medical evidence, and as my learned friend Ms. Altaf has very kindly pointed out, which we accept, the legal burden of proof falls on the appellant. And if there's no evidence either way, it's simply a case of being neither here nor there. The appellant has simply not satisfied its legal burden of proof.
Isn't it a question of looking at the medical evidence combined with the driving history, though? And his ability, or otherwise,
yes,
to manage his condition?
Yes. And if I may, and I'm grateful for that observation, Your Lordship. And in fact, that goes to the heart of the issue. The question is that, at the end of the day, the DVLA engages in a review of the appellant's condition that engages both factual issues with his driving history as well as medical issues. Now, if I may turn Your Lordship's attention to the case of Harrison, Regina and Harrison, which you will find at the case bundle at tab 1. Now, we seek to rely on this case in order to establish the general proposition, the general approach to the granting of driver's licenses. And in particular, we would seek to rely on paragraph 17. We have no evidence of, unfortunately the court is not apprised of any evidence of how the DVLA and the respondent approaches the granting of driver's licenses. However, at least insofar as history is to be concerned, if Your Lordship looks at paragraph 17, this provides, we submit that this provides at least some background as to the approach that DVLA takes. It is a high, we do not approach the matter very lightly, Your Lordship. Yes. If it pleases the court, now that I'm done with my first submission, may I move on to my second submission?
Yes, please.
My second submission is that in the event that this court makes a finding that the appellant is not a likely source of danger, we submit that on the basis of EU law and applying EU standards which are directly applicable and addressed to DVLA, the Secretary of State is obliged to refuse to grant a license. You will be able to find these. Now, in this regard, the respondent relies on a combination of a case, a high court case actually, which is Irving and Secretary of State for Transport. You'll find that in the case bundle at tab 3. And simultaneously, if your Lordship would be able to pull that up, we would also be relying on the EU directive of the European Union Directive of 2009/112/EEC. You will find that at tab 5 of the statute bundle. Now, the case of Irving concerned the grant of a license to an individual who the court found, as a matter of fact, was not a source of danger to the public. This was a finding of fact. However, the court still upheld the decision of the DVLA to refuse the granting of the license because it interpreted the statute, section 92, subsection 2b in this particular case, in line with the EU directive. If I may expound on the case of Irving further, the facts which we believe are very analogous to the case at hand. The case of Irving concerned a driver who suffered from impaired binocular vision. And the court made a finding that even though he suffered from an impaired vision, this did not affect his ability to drive at all. However, under the EU directive in force at the time, you can find this at paragraph 5, by the way. The EU directive was very clear, and it said that driving licenses shall not be issued to drivers without a normal binocular field of vision. And the EU directive was very clear on this. Even though you have if you do not have a normal binocular field of vision, you shall not be issued a driving license. So the court here was quite sympathetic to the appellant's position. They recognized that his driving ability was not affected, and he was not a source of danger to the public, in fact, but still upheld the decision to the DVLA's decision to refuse to grant a license. And the reasoning is found at paragraph 36 of the judgment. And they adopted an interpretation, if I may read out the paragraph to your Lordship, which the respondent seems to rely on, is midway down paragraph 36. So they interpreted section 92 2b in a way that says, so that if a driver of a vehicle fails to satisfy the standards required by the directive, he suffers from a disability likely to cause the driving of a vehicle by him to be a danger to the public. That was how they interpreted the section. If you do not satisfy the directives and the standards in the directive, you are under that interpretation immediately considered to be a danger to the public. Now, how this is analogous to the present case is that if your Lordship turns to point 10 of the directive, which we seek to rely on, and point 10 states very clearly at 10.2 that driving licenses should not be handed out to individuals who, sorry my Lord, pardon me, beg your Lordship's indulgence. Driving licenses shall not be issued to applicants or drivers who have recurrent severe hypoglycemia and or impaired awareness. Now this is mirrored in the motor vehicles. However, it has gone on to state that a driver with diabetes should demonstrate an understanding of the risk and adequate control. This, my Lord, is with regard to Group 1 licenses. Okay, and as my learned friend has already pointed out, Group 1 licenses are in fact less strict and more lenient than the standards in Group 2 licenses. And following on from this, for Group 2 licenses, which is directly concerned with our facts today, it is our submission that the appellant must show those factors in order to qualify as someone who is, in very simple terms, he must satisfy these conditions. Now, we do not contest that the evidence is at most ambiguous on the fact that his hypoglycemic attacks we have no evidence. There is no evidence before the court today as to whether or not his hypoglycemic attacks are severe or not. There's no evidence as to whether or not he's impaired. And in fact, the argument as to the interaction between psychosis and having an impaired awareness, we submit that that's outside of the grounds of the appeal. However, there is no evidence as to the following three requirements. If I may, have 2 minutes to summarize to finish up this point. I'm very grateful. Now, in fact, these are, in summary, not alternative conditions, but rather they are cumulative conditions. And this, of course, if your lordship requires domestic authority, your lordship would find these requirements mirrored in section 73, subsection 6 of the motor vehicle regulations, which I just referred your lordship to. Essentially, your lordship, the appellant has not fulfilled its burden of proof to demonstrate before before the DVLA, that it has his condition under appropriate control, and therefore we submit that as a result, the appellant is likely to be a source of danger, and therefore the refusal of a grant of a license is justified. Thank you.
Your Lordship, if it pleases the court today, I'm Matthew Caleris Thomas, appear on behalf of the respondent as junior counsel. Your Lordship, I benefit today really from the extensive analysis of both the statute and the physical disposition of Anthony that's come before me by the learned counsel both on our side and across the bench. I will endeavour, Your Lordship, now to be relatively brief then with how I point you to the statute so that we're not just regurgitating the points we've already seen. As you say, it's rather a complex layout and it's not very convenient, so I'll endeavour to be quick with that. I will be submitting today, Your Lordship, that essentially in this issue we find a very, very straightforward set of statutes, the 88 Act and the later 99 Act, and that this law is really uncontested, as is the psychological state of the appellant. What this issue turns on, we would submit, is the fact that when Parliament endeavours to create these regulations, it has in mind, of course, the public safety of the people around anybody driving a vehicle, and this relates to the high and strict standards facing anybody who suffers, in my case, a mental condition. Well, in my case, in the appellant's case, a mental condition, and that these standards are acute and exact ones, and that they fail to be fulfilled today by the appellant, despite him having, in general, managed his condition, which, as per the facts, we accept that he is safe in a generic way, but not in a way which satisfies the standard required here today, hence the reason that the DVLA retracted his licence. In terms of a brief rebuttal to start out with, Your Lordship, addressing a few points from the learned junior for the appellant, the position offered to the court today was really one of the appellant's having managed his condition and having a history of good driving, and we would submit, Your Lordship, that while this is incredibly commendable, it doesn't amount to any restriction on the fact that his licence requires revocation under the Act. If I could just direct Your Lordship to the Act now, tab 2 of our statute bundle. As you've seen there before, Your Lordship, Section 92, subsection 3 of the Road Traffic Act 1998 tells us that if it appears from the applicant's declaration or if on inquiry from the Secretary of State is satisfied from other information that the applicant is suffering from a relevant disability, the Secretary of State must, subject to the following provisions of this section, refuse to grant a licence, and then above Section 2A, any prescribed disability is included with that, and indeed a severe mental disorder, as the appellant has already acknowledged, he suffers from, is then allotted under Section 71 of the Motor Vehicles Driving Licence Regulation Act at tab 3. I don't direct Your Lordship because it's been substantially looked at, but if you like, that is at tab 3 there. Now, if I could just ask Your Lordship to look at tab 4 of the cases bundle.
Yes.
We find Devon County Council and Hawking, 1967 to Queen's Bench Division 26. And I believe there's a small, either yellow or pink tab, I'm not sure, paragraph 30F, really. It's a rather old, poorly printed case, but it should, I hope, be clear. And it says, here we find that so long as it is necessary for a person to be under treatment for a disease or disability, then that person must be held to be suffering from that disease or disability. Now, in this case, Your Lordship, it was contended by Mr. Hawkins that he was not suffering from a psychological disease because he did not have the relevant symptoms, and it was found by the court, as expressed there, that merely not expressing symptoms because you're on treatment is not the same as failing to suffer from the disease. So it is clear that the disease is suffered from by the appellant today under Section 71. Now, why I draw this to Your Lordship's attention is to accentuate the contrast with the cases that were cited by my learned friend, junior counsel for the appellant, because they relied there on numerous situations where people were endeavouring to deny that they suffered from the diseases that they were in fact suffering from in both those cases, and that the court examined the medical evidence with an eye to deciding on whether the person was or was not in fact ill. And in this situation, we have it clearly that the appellant was suffering from this condition and so was ill to the relevant degree. Now,
Hawkins and indeed the Swaffham Justice's case really were decided on the basis that the justices applied the wrong test, weren't they? That was why they were remitted back.
yes, indeed, Your Lordship, but
This case isn't saying that if someone's on medication and therefore has this illness, then they can't possibly have a driving licence.
no, Your Lordship, I don't intend it to mean that at all. I merely intend to establish the principle that being able to cope with your illness is not the same as not having that illness, and we can acknowledge that the management is not the same as removing the condition. And then, especially once, as my learned friend has already highlighted, we turn to the symptoms of psychosis, which is at tab 8 of our statute bundle. It's a sort of statute and relevant information bundle now. At tab 8 there, we find the symptoms of psychosis, including numerous things: delusion, hallucination, lack of insight and self-awareness, etc. So there is an acute issue with the illness that is suffered by the appellant, that it is problematic for him to self-monitor his own condition, given the nature of it. And that while we do not contend that he is currently medicated, that medication may need to be enhanced or reduced or changed, that his condition may be enhanced by, as you yourself mentioned, Your Lordship, increased stress, perhaps his hypoglycemia, other issues surrounding his life, that he would be able to self-regulate continually in the same way. Now, bearing this in mind, Your Lordship, I would ask for you to turn to tab 6 of the statute bundle, the same bundle there, which is Annex 3, Section 12 of the European Directive 2006/126/EC, which is about conditions on the required for driving licenses, and Section 11 there, which I believe again has a little tab. Section 13, which has the pink tab there, I think.
Yes.
This regulation specifically states under mental disorders, and I'm just going to jump through for clarity, but our driving licenses shall not be issued to or renewed for applicants or drivers who suffer from severe mental disturbance, such as psychosis, and then dropping down to the bottom, the penultimate line, unless their application is supported by authorised medical opinion and, if necessary, subject to regular medical checkups.
Can you equate severe mental disturbance and psychosis?
My lord, I would believe we can, and I'm only addressing this from the language that was used in the statutes here, which denote it as Section 71 of the Motor Vehicles Driving Licence Regulation, a severe mental disorder. I don't believe, Your Lordship, that a severe mental disturbance or disorder is a medical distinction in terms. Indeed, under the psychosis definition that I pointed Your Lordship to earlier, there is no such differentiation between a degree of psychosis in that way. So I would, Your Lordship, submit that this does apply to the appellant here today. He does suffer from a severe mental disturbance disorder, and therefore is required under European law to have an authorised medical opinion attached to his driving licence. And indeed, upon the fact he doesn't possess this, this certainly has bearing on the court today. And of course, I'm sure Your Lordship is aware, United Kingdom law is the courts are obliged to follow these European laws. I can, if you will indulge me, ask Your Lordship to turn to tab 3 of the case bundle, which is once again Irving and the Secretary of State for Transport 2008 EWHC. Here we find at paragraph 30 and there's actually a quotation in the paragraph that is nicely put. Are you with me, Your Lordship?
Yes, sir.
Yes. The quotation there: the fulfilment of the obligation is binding on all authorities of the member states, including, for matters within their jurisdiction, the courts. It follows that in applying national law, whether the provisions in question were adopted before or after the directive, the national court called upon to interpret it is required to do so as far as possible in light of the wording and the purpose of the directive.
Yes.
So I would submit, Your Lordship, that much as the Secretary of State is bound, if he or she were to find that the applicant for a licence did not have the mental capacity to drive, a licence must be revoked. Similarly, he is bound under these conditions to require an authorised medical opinion and, if necessary, regular medical checkups to anybody who suffers from the relevant condition of severe mental disturbance and who seeks to have a driving licence. Really, I would suggest, Your Lordship, a lot of the matter turns on this, that what it is to manage a condition is not only to be responsible for the symptoms of that condition, but to engage with it much more holistically and to understand all the requirements that are on you because you suffer from such a condition. A man such as this, who works in the public eye, in the public sector, is regularly trafficking people around as a taxi driver, is called upon to work at all different times, is not free not to drive, is not free to self-regulate, and indeed we may be to some degree unsure as to his ability to self-regulate without these medical tests because of the nature of his condition, because of the nature of the fact that he will suffer from delusions, will suffer from hallucinations, perhaps depression. And, my Lord, we see the extent of the requirements for these tests. May I just ask for a time check?
Yes, of course, it's 12 minutes.
12 minutes, okay, I should just quickly have time. We see the extent here, my Lord, because if I can refer you back to the European Regulation Annex 3, which was at tab 6, I'm sure we'll be with Section 11 now, higher up, under neurological diseases, we find that driving licenses shall not be issued to or renewed for applicants or drivers suffering from a serious neurological disease unless the application is supported by authorised medical opinion. Neurological disturbances associated with diseases or surgical intervention affecting the central or peripheral nervous system, which leads to sensory motor. There's lots of description about how they are. Deficiencies and affect balance and coordination must accordingly be taken into account in relation to their functional effects. In such cases, the issue or renewal of a licence may be subject to periodic assessment. Epileptic seizures or other, well, I won't go into epilepsy there, but I think the point, Your Lordship, my Lordship, is that we find the exact nature of the psychological issues faced by the appellant has a profound effect on the way the law affects him under this statute, and it can also be the case that neurological conditions bring out psychosis symptoms, and so it could be the case that he is in fact suffering from a neurological condition. Now, my Lordship, I don't really rely on this, and I can take you to authority we have here on that matter, but I would...
Are you submitting that psychosis is a neurological disease?
No, I'm submitting that psychosis can be a symptom of neurological diseases, and so the requirement is that we must... Well, so I bring this point up only to endeavour to show Your Lordship the need for psychiatric testing for a full understanding of the conditions. But I would also submit that my case does not rest in any way on this issue, and I brought it up as a further point, but really then returning to summarise the primary point is that there is a distinct public need to have people with severe mental conditions well regulated when they have licences like this, and finishing up, there is indeed a binding European law requirement for psychiatric assessment of such individuals, and this entails that Anthony would require such assessment before we could even begin assessment of whether the licence was relevant, and he does not have these assessments on the facts.
It's a two-stage thing, isn't it? The burden of proof on the balance of probabilities for this hearing being on the appellant, and your submission is when he hasn't provided sufficient information to discharge that burden.
Indeed, Your Lordship, you've got...
But conversely, one has to look at the absence of information available to the Secretary of State and the reasonableness of her refusal to revoke the licence in the first place.
Well, my Lordship, I would submit that she was reasonable to refuse the licence on the basis that this information was absent, and that this information, under the law, is required for these licences for people with severe mental disturbances, and so we could equally say, I would submit that precisely because this information was absent, the licence has been revoked, and had there been a positive outcome to such an assessment, there may have been more openness to the licence remaining. But as the Secretary of State is without that information, as that factual information is not before the court today, I would submit that the licence must remain revoked for policy concerns, but also primarily under the binding requirements of the European Community Law.
But under subsection 3 of section 92, the Secretary of State has to be satisfied from information that the applicant is suffering from a relevant disability, not an absence of information.
Well, if I may be allowed to continue in terms of the time, I would submit that the absence of information in some ways is information, in that she must have the relevant information before her in order to make the decision, and if that information is lacking, then she must answer in the negative because that is the requirement. And so here we have a situation where she is satisfied of the information, well, she's satisfied of the failure of the information to give the appropriate positive nod to allow the positive psychiatric report, and therefore has to revoke the licence, because otherwise I would submit, Your Lordship, that we could be in a situation where we would have no information, and it would seem that would encourage an allowance of the licence because on an entire absence of information, which wouldn't seem productive in such a situation for people who suffer from severe conditions of any kind. And so absence of the relevant information amounts to information itself in a way. I'm trying to grapple with the words of the Act here, but I think my meaning is I hope, clear in that information, I would suggest, pertains to any relevant consideration, and the absence of this case, the absence of this report is a relevant consideration, and therefore would apply here. I would also further just quickly submit that there is an admittance by the applicant here that he does suffer from the condition, and that would come under the opening of that section 3 if it appears from the applicant's declaration. So it would seem that she would be fulfilled on that count, and it may be another standard by which she assesses the absence of the psychiatric report. Thank you.
So, do you want to make any brief further representation?
My lord, respondents relied on the case of Bennington and Peter and you directed, as we saw. Before to begin my arguments, I would like to direct you to tab 7 page. Respondents admitted that without the evidence of severe hypoattack and unaware hypoattack, we cannot assume that our appellant is entitled to the license. Let me start from the severe hypoattack. Now, hypoattack, hypoglycemic attack, occurs when occurs with the symptoms. So you start feeling trembling, you start feeling shaken, and the need is to take something sweet. It is the first thing that the person does. He or she takes something sweet. If the person doesn't treat it immediately or in a short period of time, it goes to the severe hypoattack. Then the requirements of assistance is needed. In our case, we do not have medical of the severe hypoattack. Why? Because he treated hypoattack in the right time. This is an explanation. Otherwise, it would be there. And severe hypoattack occurs only in a way when it's not treated, and it has to be understood. And the fact that he had hypoattacks only during the night times, and there were also no severe hypoattacks, means that he even treated it during the night time, which is his off work time. He's not obliged to work during the night. And about the second point that they also relied about the unaware hypoattack. Again, my lord, if you can see on the page that on the top 7 that I stated to you, these guidelines exist in order to not to have unaware hypoattack. Meaning, the person, and in our case, the taxi driver, should have a regular check before he sits in the car, before he drives the car, every 2 hours while he is driving in the car. He has to look after his health, after he's driving. And the fact that he has been driving for 30 years without any incident or any severe hypoattacks means that he has been looking after his health, which explains the evidence. And if there is no evidence of hypoattack, this is why we have guidelines in order to protect, because this is something that you can't predict, and you have to check your blood, you have to check yourself all the time in order not to have such condition. Otherwise, there will be no evidence, or there will be evidence of hospitalization. But as there are no such evidence, means that he didn't have such symptoms.
I'm very grateful, my lord. The respondent would like to briefly, and indeed only very briefly, we have 2 points of rebuttal.
Yes.
The first is that, as to my learned friend's point, to recapitulate, we do not place any emphasis on the appellant's alleged awareness of hypoglycemic attacks. The facts are simply silent as to that. The second point of rebuttal is that I understand my learned friend to make the submissions that the appellant has not suffered from a severe hypoglycemic attack. Again, we struggle to, the facts speak for themselves. In fact, when Anthony has accepted that he would be unsafe in the event of a hypoglycemia the respondent submits that there's a reasonable inference to be made that he could be unsafe because of a severe hypoglycemic attack, and he could be unsafe because he could be unsafe due to a non-severe hypoglycemic attack. The respondents simply submit that at the end of the day, Anthony accepts that he's unsafe when he has a hypoglycemic attack. Building off from this, we would like to re-emphasize, again, in danger of repeating myself, this is a rebuttal, it's not a repetition. The legal test is not whether or not he suffers from a hypoglycemic attack at night or in the day. The question is whether he's likely to do so. And we submit, taking into account his history, it's definitely more than a bare possibility that he's a likely source of danger. I'm grateful. The respondents submit that this appeal disallowed. Thank you.
Thank you. I think that might be a good idea.
Okay, if everyone wants to go over to the other room, there's refreshments and stuff.
Thank you.
Maria.
Hold on. Yeah, why not? Yeah, well, just I think I don't. They're good news. They are. I think they're very thinking. Because at the end of the night, nobody's going to be reading. That's the way they are. Yeah, I know, but you're asking me who's bad. Oh yeah, no, I just don't think. I thought she was. I thought she was good. That she was good at hand. She was good at hand because she was talking. Pure. Yeah, they look good. And I think it's got the performance. But sound exactly. Yeah. And really, you could say. Yeah. That's what I was, and that might have been what I was putting more towards. Yeah. Good music. I saw good music. Yeah. But. Sorry, do you need us to leave? We're talking.
No, that's all right.
That's what they did. Yeah. It's got a response. Because it wasn't scripted. So I thought it was really good. And I thought, choose two. Yeah, initially. Yeah, it really didn't.
The first thing I would say is how very impressed I am with the general standard, I have to say. I judge a variety of different moots, most of them from people who are either pupil barristers or doing the bar finals course. And I thought the standard was as high, if not higher, than a number of the moots from people far further on in their legal careers than you are. And so congratulations to all of you. I offer a few words of advice, not in any way to either pick out individuals or praise or the opposite. I say it constructively in the hope that as you progress as advocates, that they are things that you will take on board. Advocacy is a very personal art. It's not a science at all. It's very much an art form in my view. And all of us who are professional advocates develop our own styles. And whilst one is influenced by other advocates that one sees, and that happens throughout your career, my advocacy is still developing based on other people that I see. So don't think that just because I've been doing it for 30 years and have taken silk that I know all the answers, because I don't at all. It's very important that you engage the interest of your audience, whether it be a judge, a magistrate, or a jury. And the best way to engage someone's interest is to vary your delivery. The problem with this mood, as with so many moods, is first of all you haven't got enough information. So there are a number of things that were missing from this that may have helped. And also you've got the impossible task of presenting an argument which in real life you'll probably spend 2 hours doing in 15 minutes. So it is a very artificial situation, and I sympathise to that degree. But even then, you still have to tailor what you're going to say to fit the time available, rather than like a sort of explosion, sort of chuck everything in as fast as you possibly can. Hamido, you were speaking very quickly, and whilst it was a very fluent argument, it was delivered so quickly it was quite difficult to follow it. But the fluency was very impressive. A little more ebb and flow in how you deliver it would, I think, be quite a useful thing to employ. But the content, and for both of you, I have to say, the content was excellent. The ebb and flow from you two was rather greater. I found the fact that you've got 2 bundles rather distracting. I would, unless you've got a good reason to have 2 bundles, have a single bundle which you then take the court through, rather as Anglia Ruskin did. So you're going, I found that the numbering quite odd, as to 2, 2A, 2B, and then 3 and so forth, but it was easy to follow. Dividing it up into cases and statutes for no good reason can potentially cause confusion.
Could I just ask just a quick clarification? I think the reason that we did it was thinking that there would be, maybe it didn't come up so much as we thought, but having the statute there and a case there and kind of cross-comparing.
Yes.
Do you think if that had happened more, that would have maybe justified more the division, or you still think moving would be?
I think one of the problems was that you were taking me through law, which is settled law and wasn't in dispute.
Mm-hmm.
So, for example, the EU compliance wasn't a matter in dispute, so there's no point spending time on it.
Mm-hmm.
The test to be applied in Section 92 is a clear one.
Yeah.
I have to say, I think you got the bum steerings. I mean, I think this is a pretty one-sided moot, because with a clean record of 30 years, and his conditions never having been a problem in the past. You know, the burning question, which I couldn't ask him because you don't have the answer, is, well, what has suddenly changed for the Secretary of State to suddenly revoke the licence? Whereas in real life, that would be the first question that you'd be asked. And it's an impossible question to answer because the answer is nothing's changed. We've just got a different Secretary of State and she's a bit more stroppy. So, and I'm not talking about the current minister, I'm talking in general terms, obviously. And the other thing, and I say, I don't want anyone to think that I'm being critical because I'm not, and I repeat, I'm hugely impressed at the quality of the standard. I think you've got yourself tied in a bit of a knot with the neurological disease. You know, I mean, psychosis is a very specific thing. And funnily enough, it's something I've had to learn quite a lot about because last year I defended a 15-year-old boy charged with a double murder who was running diminished responsibility, and we got psychiatrists on the one hand saying he was psychotic, and the psychiatrist on the other hand saying he was an emergent psychopath. So, believe me, I've done my research. You know, there's even an argument because it has to be a severe mental disorder, and psychosis isn't necessarily a severe mental disorder. And so I think you got yourself a little bit tied up in knots on that. And you know, going to the neurological when psychosis has nothing to do with neurology at all. But that's a matter of experience and learning, and I don't say that in any critical way because you know that really is an area, you know, for a law undergraduate to know anything about psychiatry is asking quite a lot. So there are strong points on all sides, and some points I hope to learn from as well. I have to say I don't know what other teams have been in this competition. If I could put you both through, I would. I can't make a tie because nobody goes through by the absolute narrowest of margins, and I do mean by the narrowest of margins. It goes to Anglia. Congratulations to you, commiseration chaps. With another day, another team.
Don't get that champagne now.
So the best of luck. So what's the next stage?
Quarterfinals.
Yes.
Now, before we go, I'd like to just present you with this because I know you're driving, so you can enjoy this when you get home. And I just